Okay, so in this set of two lectures, which is just actually one big lecture that I'm splitting into two, I'm going to try to talk about the sort of different legal and privacy issues and legal frameworks that surround data processing and big data, but data processing in general. I do need to say that I am not a lawyer, right? So I have read on the topic. I may be able to answer some questions. Probably a lot of questions you might have I may not be able to answer immediately, but I will look them up if you have any such questions. So I'm going to focus on UK and European legislation regarding data protection. So the Data Protection Act of 1998, which is sort of the legal framework for the UK currently. The Caldecott Principles, which sort of provide a framework for social and healthcare. Then the European General Data Protection Regulation, and something that is quite related, the European Second Payment Services Directive. And we also look, so those things are quite bland, shall I say, and very text heavy, and I'll try to talk about different ethical issues around those. Quite a few resources on that topic. I'm using, especially for the definitions, a lot of information about, a lot of information from the Information Commissioner's Office. And this is a really nice website which sort of really breaks down legislation into things that I believe are understandable by most people. And then with the new European legislation, there's been lots of consultancy firms that have issued guidance. So for instance, Bird & Bird is one of those consultancy firms, and I think their document about the general data protection is quite nice, and it has kinds of checklists. So if you were a data controller inside a company, you would follow those checklists. And then from a more general ethical point of view, so not only about legal and privacy issues, there is this book which is a collection of chapters on different related issues on ethical reasoning in big data. So let's start with the law as it is in the UK. So the Data Protection Act of 1998, or DPA, is an act of Parliament designed to protect personal data stored in a filing system. And since it's from 1988, it's both a computer system or some kind of organized paper filing system. And even though it's UK law, it implements the EU Data Protection Directive of 1995, which is about protection, processing, and movement of data. So there are loads of different definitions that you might expect in this kind of legislation. I've tried to select some of those that are more relevant to us. So for instance, in this legislation, personal data means data which relates to a living individual and who can be identified from those data. So if the data by itself cannot be used to identify an individual, it's not really considered as personal data. Or it's regarded as personal data if those data and other additional data in the possession of a data controller can be used to identify an individual. And here, a data controller is a person in the legal sense, so it might be a company as well, who says how and why personal data is processed. So as always in my slides, there are links almost everywhere. If you want to read more, you can go and check the links there. So within personal data, you've got what is called sensitive personal data, which sort of breaks down into more details the different types of sensitive data. So racial or ethnic origin, political opinions, religious beliefs, or beliefs of a similar nature. Being part of a trade union, this is something that people might not necessarily associate with sensitive data. A person's physical or mental health, their sexual life, be it orientation or practices in general, the commission or allegation or alleged commission by that person of any offense. So if someone has committed an offense, or if he's accused of having committed an offense, then this is sensitive personal data. And then anything that relates to this offense and being prosecuted about it. So it's an act about processing data, so it's important to know what processing means in this framework. So it's obtaining, recording, or holding the information or data, or carrying out any operation or set of operations on the information or data. And this is further broken down into organization, adaptation, alteration, retrieval, consultation, or use, and also the disclosure of the information or data by transmission, dissemination, or otherwise making it available in some fashion. And then alignment, combination, blocking, erasure, and destruction is also within what is called processing. So there are about 7 to 8 main principles in the Data Protection Act that the data controllers are supposed to enforce. And the first one is that data needs to be processed fairly and lawfully. The little ellipsis over there is that then there are some exceptions and specific cases for application, so you can look that up. But in general, it's supposed to be processed fairly and lawfully. The second one is that you need to obtain the data, store it in a database or something like that, for one or more specified and lawful purposes. So you need to specify why you are using the data and what is the purpose of the data. The data that you're storing needs to be adequate, relevant, and not excessive. So it's not just about collecting a whole amount of data, as is often the case with big data applications. If it's about personal data, it needs to be adequate, relevant, and not excessive. You should also make every attempt for it to be accurate and, where necessary, up to date, because people's situations might change. Something that is not necessarily, that you don't necessarily think about first is that you should keep it for a specific amount of time, or at least for some time that is not longer than necessary. And then the different data subjects have rights. Since those sort of overlap a lot with GDPR rights, I'll talk about those rights later on when I talk about the GDPR, but I'll give an example just afterwards of this and about something that you might have read recently. And then the last two are sort of more technical aspects of the principles, where the seventh one is about having the appropriate technical and organizational measures, so enforcing security about the data. So you should protect your data. and not make it easy for a system to be hacked or have intruders come into the system and steal the data. And then the last principle is about whether the data can be transferred or not outside the European Economic Area. So it can be transferred if the country or territory where it is transferred to ensures an adequate level of protection for the rights and freedoms of data subjects. So one of the rights under the Data Protection Act is the subject access request. And this is where, as an individual, as a data subject, you can ask through a written request and by paying a fee to be told what personal data is being held about you. And as a data processor, you will need to comply with that. You are entitled to be given a description of personal data that is being held about you, the reasons it is being processed, and whether it has been given to other organizations. And you're also entitled to be given a copy of information comprising the data and any details. So you might have read, and that was last month, that someone requested their Tinder history, so their online dating history through their Tinder app. And having used this app for a few years, they got back 800 pages of fairly detailed and very personal data. So that shows both that the law is working, at least for that person. In some cases, it has proven quite difficult to obtain. And also it shows the amount of data that is being stored and that can be queried about you.
Excuse me.
Yeah.
The new regulation here, are you talking about a GDPR or a DPA
Currently I'm talking about DPA.
But I think that one is something that we use here, isn't it relating to the GDPR?
Sorry?
I think that the information here it sounds like it's a new regulation. It's not like the old one.
The old one, the new and the old one actually have a lot in common. It's not as if the GDPR is going to, well, it is in a sense going to overhaul a lot of things, but the main basic principles are there, right? The principles of the GDPR are still the ones that I cited with additional things tacked on.
Because I think that before the GDPR, people never asked for the information from social media or something like that.
Well,
isn't it?
this person did that this year, and the GDPR comes into full force next year. So it is possible, but it's not necessarily very easy. You have to pay a fee. With the GDPR, this is supposed to be free unless you make multiple requests, then they can start to bill you.
Isn't it applicable on only those companies which operate within UK, because if some company is not operating in UK and they are based in some other country, they may not be obliged to give data even against the payment of fee?
Yes. So with the Data Protection Act and the European Directive, this is for companies that operate within the UK. With the GDPR, this will be for all companies that process data from European residents.
Even some American companies, they migrated their data onto cloud because they do not want to give some information to their own organizations, saying that data is not hosted in US, so this law is not applicable on them.
With the GDPR, even if you migrate to the cloud, as long as you are processing European residents' data, then there is a kind of flow of legal requirements for everyone who is processing the data. So even the cloud provider is required to comply with the GDPR. So I'm going to talk about the new regulation and the sort of changes about the GDPR, but before that, I still want to stay in the UK, although the GDPR will still be applicable in the UK, and talk about a little bit about confidentiality and health and social care in the UK. And those are sort of enshrined in what are called the Caldecott Principles, and the name comes from the chair of a committee that put forward those principles, so Dame Fiona Caldecott. And initially they set out the first 6 principles, and then later on through consultation the 7th one was added. So they sort of look a little bit like the Data Protection Act principles, and this is normal because they need to be able to interact between the two. And so the first one is to justify the purposes when you're collecting data about health and social care. You don't want to use patient identifiable information unless it's necessary, so that's information that identifies a specific patient. You want to use the minimum necessary amount of patient identifiable information. Access to this information should be on a strict need-to-know basis. Everyone with access to this information should be aware of their responsibilities and understand and comply with the law. And then the last one is that the duty to share information can be more important, can be as important as the duty to protect patient confidentiality. So it's sort of slightly strange, this last one, but it's in the case where the well-being of a patient is at risk, then if sharing some information, let's say with a medical professional, might help in that situation, then it's more important than protecting the confidentiality. But let's go to the European Data Protection Regulation, or GDPR. So it's an EU regulation that's intended to strengthen and unify data protection for all individuals within the EU. So you don't need to be an EU citizen as long as you are living within the EU. This is a framework that protects your rights. And it applies to all entities, including foreign ones, that handle and process data of EU residents, and has severe penalties in case of failure to comply. And I'll go through the penalties in the next hour, actually. So more specifically, the GDPR applies to controllers and processors, and those are terms that were already used in the Data Protection Act. The controller, as I said before, says how and why personal data is processed, and then the processor acts on the controller's behalf. Like the Data Protection Act, and as I said, there's a lot of overlap, the GDPR applies to personal data. However, their definition is more detailed, and it is explicitly mentioned that identifiers, online identifiers such as an IP address, can be personal data, or a unique device ID. So your phone has a unique device ID, or your computer has a unique device ID in the form of a MAC address, is also personal data. Whereas with the Data Protection Act and the other national legislation in the EU, that was not necessarily the case. So companies could just collect IP addresses like that. The GDPR also refers to sensitive personal data, and they are classified as special categories of personal data, and they include genetic data and biometric data, where those are processed to uniquely identify an individual. So again, if you can tie the data back to the individual, then it's sensitive. So you might ask yourself, well, why do we need a new regulation, especially since there is that much overlap? You could maybe just add a few amendments to the legislation. But I think it's important to sort of go back in time and see what was the context at that time. And I'm doing it in a, I guess, maybe not a really convincing way, but I think maybe a slightly amusing way. So back in 1995, when the European directive that was the basis for the Data Protection Act was created, the internet was in its infancy. People still used floppy disks, and here I'm going to show you a few seconds of computer program that was sort of showcasing the first internet cafes, things like that.
Who says online users are a bunch of anti-social geeks? Look, here we are in this nice cafe, drinking and friendly people, and we're surfing the net. This is the Icon Bite Bar and Grill in San Francisco, where you get the best of both worlds, real people and virtual people. You can come in here and sit down, have a drink, socialize, and check out some cool websites, look at your email, or log on to your favorite news groups. Today we'll show you the growing power of the internet on this edition of the Computer Chronicles.
So there's a CRT monitor, there's an internet cafe. I don't think that really exists anymore, maybe for hipsters. Yes, he's talking about news groups. Well, now there's Reddit and things like that. Actually, in the rest of the program, they talk about how to use email and how to write a small HTML page or something like that. And I'll still show you a few more seconds, which is the opening intro, which is magnificently outdated, but I really like it. Okay, that's it. Actually, it was quite a nice program. No. There's the link here if you want. There's a full 27 minutes of... Why? Okay, so the other thing when that loads. So the internet was in its infancy, and I think it's nice to have some numbers about that. So in the UK, in 1998, less than 10% of households had internet access, and computers as well were the number of households with computers was quite low. And now, today in 2017, about 90% of British households have internet access. So I'm not entirely sure why they switched from UK to Great Britain in the Office of National Statistics, but yes, the statistics are like that. In terms of coming back to the GDPR and that sort of timeline of things, so now you're hearing about people saying, oh, there's a GDPR next year, we need to be compliant. And it seems that people are rushing things and haven't really thought about that. But this is something that is years in the making and has been planned for several years. So in 2011, the EU Commission put forward proposals for a new law. Actually, they leaked sort of a very rough draft of a law to sort of test the waters and see what people were thinking. In 2012, there was an official draft of a tweaked version of this 2011 version, sort of a toned down version, and it's reportedly the most, or one of the most heavily lobbied pieces of legislation with over 3,000 amendments. And then the regulation itself was published in the official journal and entered into force in 2016, in May 2016. And there has been, we are currently in a 2-year post-adoption, so the GDPR is adopted. We are in a 2-year post-adoption grace period currently. So people who are just waking up now and realizing that they need to implement stuff can't complain too much about being given the time to put things into place. So in May 2018, and I forgot to put the exact date, but I believe it's the 25th of May 2018, the GDPR will become fully enforceable throughout the European Union. And with all the penalties that come with it, well, that's what we suspect, and I'll talk about the penalties later, if you don't play by the rules of a GDPR.
Excuse me.
Yeah.
Is this enforced in UK from May 2018, given the crisis?
Yes. I have to, this is coming up in, not the next slide, but in 2 slides. So good question. Just before that, I want to make the distinction between a directive and a regulation. So the Data Protection Act was based on the Data Protection Directive of the European Union, and here the GDPR is a regulation. So there's a difference between those two legal instruments. So both actually are passed at EU level, but a directive needs to be implemented by the different countries of the EU. So the UK implemented the Data Protection Directive within the Data Protection Act. With a regulation, you don't need to have a national implementation. It's just the law as it is, as the regulation as it has been passed by the EU that becomes law throughout the EU. And so with the different implementations, this leads to different national variations of the implementation, whereas with a regulation it's much more homogeneous. It's the same law throughout, although there are still national exceptions and interpretations. For instance, you have exceptions for national security, you have exceptions in terms of policing and things like that, which might make it not exactly the same throughout the different countries.
Can I ask a question?
Yes.
Does it mean like after the regulation issues at EU level, each nation need to have their own directive to make it enforced in their own countries? Because I understand that no need for national implementation.
Yes. With a regulation, you don't need to have an act of parliament to put it in force.
So it means that it's enforced in every country within EU countries. No need for another directive.
Exactly. So that's the difference between a directive and a regulation.
Excuse me, the exemptions and interpretations are different. Are they agreeable between the nation and the EU party? How do you come to agreement what is an exception? Is it the EU decides or the nation decides, or between the two of them?
Okay, so this sort of is from the other limit of my knowledge, but in the regulation itself, it already specifies that there are exceptions that the different countries, it defines sort of subsets of the law that the different countries can interpret in some way. So for instance, if it is with respect to terrorism prevention or law enforcement, not necessarily all law enforcement, but some law enforcement.
So these are predetermined within the
Yes.
regulation.
So, this I'm sure. Then maybe there might be other things that they need to, but then I don't know about that.
After Brexit, they will become white.
Brexit. The UK government has confirmed that the UK's decision to leave the EU will not affect the commencement of a GDPR. So in May 2018, the GDPR will be fully enforceable in the UK. After that, so in 2019, when Brexit is Brexit, the UK will still need to do business with Europe anyway. And actually, all countries that do business with Europe, or all companies from the different countries that do business dealing with EU citizens' data, will sort of need to conform in some way or another with the GDPR. And this is a concept of extraterritoriality. So with the current law, so with the Data Protection Act, or the different laws in the different European countries, this law applies if the establishment or equipment is within the EU. With the new law, as long as you're in any of those following situations, then the new law applies. So if the establishment is within the EU, as previously, if the goods or services are provided to EU residents, and that does not necessarily mean payment, so if you are using a free service, it's still the case, and if the behavior of EU residents is being monitored. So companies outside the EU need to comply, and this is what is also called the country of destination rule. So if, let's say, your company is within the US, you need to comply with US data protection laws. But if you are handling a European citizen's data, you also need to comply, you will need to comply with EU regulation. One thing that is potentially slightly tricky, well, actually it is tricky with extraterritoriality, is that how do you enforce any penalties? So if you have this US company which is only in the US, no one from that company ever goes to the EU, and they handle EU residents' data, and they handle this data improperly. How do you enforce the penalties? And this is something that is a little bit unclear, at least to me, but I think from what I've read, for quite a lot of people, how they would sort of enforce the different penalties. In terms of different obligations of the processors, so with the current law, it's the data controllers who have sort of all the obligations about enforcing all the different principles and rights. And making sure that those are within the company policy and things like that. But the processors, so the sort of providers for the different services that the controllers use, just don't need to do anything. So there are no obligations for processors. With the new regulation, there is direct accountability of processors. So there's a flow of the same legal terms through the different levels of customers, processors, sub-processors, subcontractors, whatever you want to call them. So, and this is going to have a major impact on the cloud industry, because let's say currently if you have an app which is running on a cloud service, it's the makers of the app who are going to handle all the data protection, who are supposed to handle all the data protection stuff. But now with a new regulation, everything, all the legal implications trickle down to the processors as well. So if there are sensitive information which are stored in the cloud, the processor needs to pay attention to all the different aspects of a legislation and cannot just say, oh, I'm just providing a service and this is a responsibility of whoever is using my cloud service. So one thing that is quite new, and this is a new word for me as well, in the GDPR, is pseudonymization. So you've probably heard about anonymizing data already, but actually really anonymizing data is quite difficult and potentially impossible. to really anonymize data that can never be traced back to someone. So in the GDPR, you have this concept of pseudonymization, where the processing of personal data in such a way that data can no longer be attributed to a specific data subject without the use of additional information. So I think the important bit is without the use of additional information. So it's not necessarily completely anonymized, but some effort has been put into making it sort of pseudo-anonymized. So for instance, if you're using a hashing algorithm, so an algorithm that takes in some kind of input, let's say personal data, and then spits out a number, and that this algorithm is not easily reverse engineered, then you would be in a context of pseudonymization. So to pseudonymize a data set, the additional information must be kept separately and subject to technical and organizational measures to ensure non-attribution to an identified or identifiable person. So again, this concept of additional information which needs to be kept separate. And by defining pseudonymized data, this allows the regulation to sort of relax a little bit the rules for instance, when there is a data breach of pseudonymized data, the regulators, you don't have as many stringent constraints about what you need to report to regulators or to the individuals whose data has been compromised. And also when you're doing profiling on pseudonymized data, there are not as many stringent constraints. So with respect to pseudonymization, I thought it would be interesting to talk about de-anonymization or re-identification. So this is sort of to illustrate the concept that it's really difficult to have anonymous data or to anonymize data, even when it's done very well, but especially when it's done badly, when anonymization is done badly. And so de-anonymization or re-identification is about collecting enough anonymous, with air quotes, information about an individual, mining the data to create a profile of a unique person, then trying to link the profile back to other public information to attach an identity to the data. So this is clearly possible in theory and has been demonstrated in research, and I'll give you some examples now. So, and those examples sort of date from a bit before 2005 to just recently. So for instance, if you take healthcare data, so in Massachusetts, the GIC is responsible for purchasing health insurance for state employees. And so it has a database of different health information with personal data attached to it. And they thought they were doing a good thing by giving the data, the anonymized data, giving it freely away to researchers and companies so that they can build better models either for research or for their companies. However, their anonymization meant just stripping the social security numbers and things like names and addresses, but they still left in zip codes, birth dates, and gender. So this is a sort of anonymized, with air quotes, data set. In parallel, you can buy a voter list of the county of Cambridge in Massachusetts for $20, which includes the name, address, zip code, birth date, and gender of each voter. And the two data sets, since there are overlapping fields, can be linked, so with those three overlapping fields of zip code, birth date, and gender. The sort of slightly comical thing is that a researcher managed to link William Weld, who was governor of Massachusetts at the time. So using the voter data, she looked up his birthday. There were 6 people in the county of Cambridge where he lived. Only 3 of them were men. She had this gender information, and he was the only one living in that zip code. So it's especially interesting about this governor because at the time, well, a little bit before, he had fainted when giving a speech, and no one knew what health condition he was suffering from, but this sort of allowed people to pore through his health history. And this is the main question here. So actually, in the United States, if you have the zip code, the gender, and the birth date, it's almost sure that you can identify a person. And this is probably going to be the case in the UK because zip codes are even smaller in the UK. Well, postcodes are even smaller in the UK, so it's quite probably the case. Another example of de-anonymization is with the Netflix dataset. So you might have heard that a few years back, Netflix had this big competition where they gave out a dataset of 500,000 subscribers, anonymized dataset, here sort of anonymized properly. And the aim of a competition was to come up with an algorithm to suggest movies based on what you had watched before, so your interests. And what researchers found out is that an adversary who knows only a little bit about an individual subscriber can easily identify this subscriber's record in the dataset. So using the publicly available Internet Movie Database as a source of background knowledge, the Netflix records, which are anonymized, can be used to identify users successfully. So for instance, if you had 8 movie ratings from IMDb, the Internet Movie Database, 2 of which might be completely wrong, and you sort of knew when the person had made those ratings, then you could uniquely identify 99% of records. And even if you only had 2 publicly available ratings, but with sort of smaller time windows for when they were rated, you could still identify 68% of the records. So you might think that this is maybe a little bit trivial, but let's say you have this, you're watching Netflix in the comfort of your home. You might be watching stuff that you won't necessarily want to rate on a public website, right? So movies that might interest you, that might be related to your political affiliation, your gender, your sexual orientation, things like that. So while it might sound trivial, it's still able to reflect personal information.
What is it, 14 days, the 3 days? How to explain? Is that on the date of what?
It's on the date of a rating, or when the rating was made. And my final example here of de-anonymizing things, and this is a very recent thing because this is a publication from this year, is de-anonymizing web browsing data with social networks. So anonymized browsing histories can be linked to social media profiles using only publicly available data. So you might have anonymized browsing histories when you allow Google Chrome to track your history, or just by doing web searches and things like that. Usually those are anonymized. And then what the researchers, the hypothesis was that each person has a distinct social network, and there's a set of links that appear in one's feed in that network are sort of going to be reflect their browsing history, because obviously if you're posting a link, you have been on that page, right? And it's in your history. So what they found out is that if they had a history of 30 links originating from Twitter, the corresponding Twitter profile could be deduced more than 50% of the time. So it's not as sort of accurate as with the Netflix data, but still this is on a much larger scale with data that is probably more readily accessible because, for instance, Twitter data is easily mineable. It's public data. And it's also quite striking because there are several online trackers, so advertising trackers, that are embedded on sufficiently many websites to carry out this kind of attack with high accuracy. So if you have, you know that advertising is quite centralized. There are not that many different advertising companies that sort of run most of the advertising on the web. And there are going to be loads of websites using the same advertising trackers. So this is quite scary, I think, in some sense. And I think I will stop here for now. I need a drink of water anyway, and then we'll start back in the following lecture on data protection principles.
Website is a question. It says, do all the web pages have the access to all the other pages cookies?